Oh, really? Okay, so I gotta get a forklift there.
So,
I put on there for them to call.
yeah.
Okay.
You have one, but I'll go.
Mechanics, but I was self-active.
No, I'll show it to you.
Directly in front of you.
What a fabulous game last night. First inning, they're out of it. To sit there and watch those people sunk through 8 innings of baseball. Well, it was 6-0 after the first, no, 4-0 after the first inning, and 6-0 after the second inning. And they lost.
Nine.
Went to work, I was talking to my manager, and I went to work on Tuesday when they lost. No, on Wednesday morning, when they lost 3-0, they're down 3-0. And I said, hey, Steve, did you watch the baseball game last night? He said, yeah. I said, I wasn't sure, but at the 8th inning, I was sure that I saw the goal out there in the outfield behind me.
That's what they were singing now. Big mass, you wouldn't have that last week. No, next year.
I gotta be honest.
No, I agree. Yeah, that was the locker. Here's the work with. You want to work with a great company.
Good, good.
Good evening, everybody. Welcome to the Town of Waukesha Town Board meeting on October 22nd, 2015, beginning at 6:30. I'd like to call the meeting to order and begin with the Pledge of Allegiance. And Madam Clerk, have we met all the open meetings laws requirements?
Yes, we have.
And we can begin with citizens' comments. I'm sorry, and a roll call.
Supervisor Durr,
Here.
Supervisor Fisher,
Here.
Chairman Merrick,
Present.
Supervisor Radke,
Here.
Supervisor Wolf.
Here.
And now we can begin with citizens' comments. Yes. And we can move on to approval of the minutes from September 24th, the joint meeting with Big Bend, and October 8th, the town board meeting. If there's no objection, we can take these together. Is there a motion?
We can't take them together. I wasn't present at the first one.
Oh, okay.
I'll make a motion that we approve the minutes from September 24th, 2015, which was the joint meeting with Big Bend.
Second that. Any discussion? All in favor?
Aye.
Opposed? Motion carries. On to abstain.
Yeah, aye.
And on to B, October 8th, 2015, town board meeting. Is there a motion?
I'll make a motion we approve the minutes from October 8th, 2015.
And a second?
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries. On to report 6, beginning with the fire department. Good evening, Chief.
September was a relatively slow month for us. We had 25 ambulance requests, 6 vehicle accidents, 11 fire responses. Mutual aid was given 3 times and received mutual aid 3 times. 1 person left the department in September. We're at 36 active members, 2 people are on leave of absence, a secretary treasurer, and 2 high school cadets. Our open house and fire prevention, we started off very, very well. Our open house brought in over 1,200 participants this year. It was a huge success. We probably raised about $6,000. Right now, we still don't have a final count, but it's getting pretty close. We continued the week at Rose Glen School on October 9th with presentations to all grades, kindergarten through 5th grade, both indoor programs and outdoor activities for the kids. 4th and 5th graders put into practice the things that they've learned since kindergarten and did participate in the fire prevention challenge relay this year. So that was a pretty good adventure for them. And the backup ambulance is now in the garage and loaded and was going to be put in service today, but we ran into a radio glitch and now the radio guy's coming tomorrow to fix that. So it should go back into service tomorrow.
Good. Any questions for the chief?
Just one real quick question shortly down the agenda. We've got talking about auctioning the old ambulance. If we get any questions at that point in time or anything, are you going to be around for a couple minutes or are you leaving momentarily?
No, I can stay for that.
Thank you.
Thank you, Chief. And Deputy Fransky.
For our stats, the month of September, we had 87 calls for service, 4 911 hangups, 3 alarms, 15 assist other agencies, 11 assist fire EMS, 6 disabled vehicles, 34 house and building checks, 1 suspicious vehicles, 31 citations, 2 written warnings, 24 verbal warnings, 1 ordinance citation, 1 warrant pickup, 7 citizen service walk-ins, 10 follow-up investigations, 2 well-being checks, 1 railroad complaint. Traffic accidents, we had 2 property damage, 3 personal injury accidents, 1 OWI, 1 tow-away offense, 6 animal cases, 1 burglary, 1 controlled substance, 1 disorderly conduct, 3 frauds, 4 loud noise, 1 missing person, 1 recovered property, 2 thefts, 0 suicides, 1 threat, 3 violation of court orders, and 4 other offenses.
Thank you. Any questions for Deputy Fransky? None? All right. Thank you.
Thanks.
And Madam Clerk.
I sent out the letters to the up the drinks that got the complimentary Apple Drive. We had 55 people on the list. So far, 11 of them have contacted us that they do not qualify for that service. So that'll be opening up some spaces for others in the town. Notice of the town board, the town meeting, and the budget has been will be placed in the paper on Saturday, and we've set up our audit and prelim meeting with the auditors.
Thank you. And Supervisor Fisher, well monitoring.
I have nothing further to report tonight. I hope to have updated information for you at the next meeting, so I would ask the clerk if you would put that on the agenda for our next meeting. Thank you.
Thank you. On to 7, new business, discussion and possible action on the following: an operator's license for David Jobin for Tally's Tap and Eatery. Is there a motion?
Make a motion to approve the operator's license for David Jobin.
And a second?
I'll second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries. On to B, approval of the 2015 tax collection agreement with Waukesha County. Madam Clerk?
This contract or agreement is the same as we have been for the last few years. There has not been an increase in cost, and the county has been doing an excellent job in collecting our taxes. So ask for approval.
Is there a motion?
I'll make a motion that we approve the 2015 tax collection agreement with Waukesha County.
And a second?
I'll second.
Any discussion?
Question, which one of these do we do? Do we have our own bank or do we use theirs? On the back page?
We do have a lockbox, which reduces our
Okay,
cost.
so we pay the 155?
Yep.
Anything else? All in favor?
Aye.
Opposed? Motion carries. On to C, authorize the clerk treasurer to send the town's ambulance number 1652 to auction. Proceeds from the auction shall be deposited into the capital project fund. Supervisor Fisher?
Well, so we can discuss this item, I'll put a motion on the table, and the motion would be to authorize the clerk treasurer to send the town's ambulance number 1652 to auction, with the proceeds from the auction to be deposited into the capital project fund for use for future capital projects, and I so move.
Second?
I'll second that.
Discussion?
Just a quick question, I was certainly made the motion, certainly supported. Do we know anything about the mechanics or timing or just any of the rough shape of what this looks like, or is that to be determined?
I think the chief would be the best person to answer that question.
Okay. You mean what the rate looks like? No, I mean, just about the auction thing. I mean, is this something that we're authorizing it to, is this something that the
I'm sorry, I
clerk
thought you
is
meant
doing? No, I'm talking about just how we go about doing the auctioning and that type of thing.
Right, we sign up, we'll take some pictures. I'll have Dan write something up about the vehicle if there's any concerns with it, and then we'll put it on the auction site, and they'll let us know when the final bid is on.
Okay, thank you.
Any other questions?
So we expect it to be on the site by,
We've already got contact. We made contact today. Tomorrow I can sign us up and put the pictures up. Hopefully by Wednesday we should be on the site.
and then it goes for, how long is the auction?
I don't know that.
Okay.
I think typically they're up for 3 weeks.
Is the procedure then, again, I don't know it, we'll certainly have no desire to keep it, but are we committed, assuming that we do get people who respond to the auction, are we committed then to part with it? I mean, is that the understanding of proceeding in this manner?
We can put a reserve on it if you so chose.
Okay.
Now that you brought it up, did we have anyone that wanted to put a reserve on our ambulance? Thank you.
Anything further? All in favor?
Aye.
Aye.
Opposed? Motion carries. On to D, Nick Tretter's request to waive the legal fees for the non-compliant property that is now heading towards compliance. And Mr. Tretter's here with us.
Hey, good evening, board. Thanks for having me. Appreciate you guys putting us on the agenda for this evening and listening to me again. If you guys haven't been by the property though, you guys may have noticed some really good progress. The house is down and pretty much gone as of today. My brother's, one of his best friends, owns an excavating company. We finally got the permit and everything from Mr. Montoya. So if you guys get a chance, take a ride over there. It, in my world, looks pretty because it's gone or almost gone. So, but again, thank you for the extension. Tonight, what I wanted to do is talk to you a little bit about the possibility. We respectfully ask that you guys look to waive the attorney fees. I received the bill in the paper, and I was quite frankly rather surprised to be getting the bill based on the dates that are listed in the bill and when the actual attorney fees were initiated versus conversations that I not only had with John and commitment from, Chairman John, also based on the commitment from Chairman John as it relates to withholding or stopping any attorney actions. And then looking at the dates and how they all work out, it just goes against what we all committed to. At the end of the day, we feel, we being my brother and I, have quite frankly listened to the board, and we've acted in very good faith based on what your expectations were. I don't think there was a single point that we did not act as you guys wanted us to. The discouraging piece was we had bought, we had taken ownership of the property, and within 1 month, we had already had a lawsuit put against us. However, when you look at the previous owner, I understand you guys, the board was eagerly pursuing the previous owner to have that property raised for 1.5 years, and nothing happened. And after 1 month of owning the property, we had a lawsuit slapped on us, which we quite frankly thought was unfair. But I did speak with Chairman John, and the agreement was based on the story that we had given him, that it wasn't just a internal family transfer. Quite frankly, I don't see my Aunt Butchie ever. I haven't seen her for years. But when we caught wind that she was looking at donating the land in the house because she couldn't afford to remove it, we said, we want to keep it in the family. This is land that is important to our family. My brother and I, and my plan is to have my son grow up on that land, riding dirt bikes and going out there and helping my grandmother cut the lawn and take care of the house. So at that point, we said, we've got the funds to take the house down. Let us take the land. And that's why we brought the land into our ownership. So when you look at the dates and how everything worked out, I was a little surprised to get the bill. So I'm just asking the board to take it into consideration that we waive the fees. I understand it's only $320, but it's important to us because everything that's happening on this property right now is coming out of our own pockets. And I get it. We took the commitment. We took the ownership of the property. We took the responsibility of removing that house, and we are. And quite frankly, if you look at what we discussed last time, or the agreement we made was we get a first month extension, and then we'll get an extra 30 days based on the asbestos results. I think that takes us to like the 26th or something like that. We'll have the house removed and hauled away by tomorrow. So we met your demands, and we said we would, and we did. We never have a problem doing that. But now based on how the attorney fees worked out, we're just asking that we get these waived.
Point of clarification, I think the first time we talked about attorney's fees and stopping them was last week, mid last week?
No. Well, no, based on my records, I've got it as August 18th when we had a conversation. At that point, you and I had a conversation about what the situation. I think the board was in the mind that we were transferring land within family, and we figured you guys were just doing that to buy time. Now, Nick, that I understand why you're transferring the land within family and you're going to do something, I'll call off the attorney. And that happened on August 18th.
Okay. What I said was we would stop pursuing a lawsuit.
Okay.
But there's still legal fees incurred because he's still involved in looking over situations within the town of Waukesha.
Okay. So I guess my question then is, if I look at when the actual attorney fees were initiated, or the attorney was initiated, that was based on the document 7/30. Okay, 7/30 of 2015. We're being charged $87. I'm assuming that's the initiation fee for the lawsuit. Now, I don't know if I'm right or wrong, but I'm assuming it is, because that's the first time that the lawyer is now getting involved with us. However, if you go back and look at the timeline when we were actually asked to come and get in front of the board, and when the board actually initiated the lawsuit and told us, that wasn't until August 13th. So I'm looking at a bill that I'm getting initiated on 7/30, and at that point, no lawsuit was initiated. Your board meeting on the 13th approved the attorney to initiate a long form summons and complaint, which is 2 weeks after my initial charge on 7/30. I don't even think we had talked to you guys at that point. We're already getting hit. And then legal fees from 8/14 to 9/16 incurred after that. So those are the dates I have.
The initial fee would have been consulting with town staff, myself, with the attorney to figure out how we're going to pursue moving forward. That's the initial.
Okay.
Then on the 14th and moving forward, those charges would be for initial work for him to start the summons and long form complaint, which then was, quite frankly, you've gotten off pretty cheap, because had they moved faster, it would have been in court within days. Another bill there.
Okay. Can I ask a question?
Sure.
Was there ever a long form summons or lawsuit leveraged against the previous owner?
No.
Okay. So I'm asking the question, if you guys were after the previous owner for 1.5 years to have that property raised, and you never did anything, why are we then getting hit with a lawsuit after owning for a month? And I'm still trying to figure out why we would even be in a lawsuit conversation if we only own the property for a month. And then as we moved on from the first conversation, we said we were going to go get asbestos tested. We did. We said we're going to get it removed. We did. Joined every single meeting. I said I would, and I did. And rightfully so, you guys let me slide and just sent an email update, and I appreciate that. But I get it. I'm having a hard time understanding why you go 1 year to 1.5 years and not hit a lawsuit on the previous owner, but because we miss a meeting, I'm hit with a lawsuit. It makes no sense.
So my take on that from sitting over here is that the issue follows the property.
Okay?
And I understand why you feel like the lawsuit was initiated to you. But from my point of view, sitting on this side of the bench, we struggled with this issue for, as you said, 1.5 years, and had pursued and discussed it at multiple meetings.
Right.
And so the issue followed the property. It wasn't that we were filing the lawsuit on you. We were filing the lawsuit to resolve the issue. It just so happened that a month before you purchased the property.
Yeah, that's a hard one to buy.
And
I understand where you're coming from.
I mean, the past bills and the bills that are attached to the property, no matter what sale in real estate, typically follow the
Yeah,
property.
I get that, but why did it coincidentally happened a month after we took ownership, and quite frankly, the day we missed the meeting. Listen, I explained to Chairman John, I'm a father, 2 children and one that works, and I got to support my family. My brother owns a plumbing company. He works 18 hours a day. Okay. And I explained to Chairman John, I said, initially we wanted a 4-month plan, a 4-month time frame to remove this house, because we can only work on it on the weekends. We can't go over there during the day, right? Chairman John said, well, I could probably have the house down in 2 weeks. And I get that, but I don't have the machinery. I have to hire somebody. I have to schedule, I have to coordinate. I got to pay for it. I got to come up with the money. And I can only do it on the weekends. And actually I had to take off today and tomorrow to get rid of the house. So I understand, Supervisor Gore, where you're coming from. But it just seems from my perspective that the frustration and the anger, and maybe I'm wrong, the frustration and the anger with not being able to get this house removed for the last year and a half from the previous owner was taken out on us. Because we said, yeah, we got the money to remove it. Well, then we're going to start pushing them along. And I think it also stemmed from a misunderstanding from the board that, and quite frankly, an assumption that we were internally in the family transferring this land so that we could buy another year. And that was not the case. We're trying to keep it in our family because it's important to us, because our childhood memories are from that land.
Understand.
There was, first of all, let me back up. There was no frustration or anger directed at anybody. And it wasn't a coincidence that it happened after you bought it. We had been in the planning stages of initiating a lawsuit for quite some time. It happened at that point.
And so then I respectfully asked, why didn't you guys give us a chance to follow through on our commitments? We missed one meeting. And why we missed the meeting? Again, I mean, quite frankly, I was with clients up at Whistling Straits. I didn't get home until 10 o'clock. I physically couldn't be here. My brother runs a small company. He had to go take care of his biggest client. He couldn't be here. That was, I get it. We missed the one meeting. Fine, we get one strike. But then you guys immediately moved to hitting us with the legal fee, or with the lawsuit that day. And I get it, it's in the works. But why didn't we get a chance? I think it's unfair.
We did give you a chance. As a matter of fact, we pulled back the lawsuit. That's something that the attorney was directed to follow through on that. Quite frankly, he should have followed through on it. We should not have pulled him back. We should have had another board meeting, and he would have been working on that the whole time. We meet twice a month here. It happened on that day. Had there been an explanation that day before we went into closed session, perhaps there would have been a different outcome, but that simply wasn't the case.
Okay. So you're telling me you guys don't have the ability then to stop legal involvement?
Absolutely, the board does. The board
does. The board does. Okay.
And we did.
You did. You stopped the lawsuit, but then how come, if I look at the dates, if you stop the lawsuit, which means, and maybe I'm wrong, you stop the lawsuit, that means the attorney stops working on that particular case.
No.
Unfortunately, no.
Okay, so he still reviews emails and this and that.
Yes.
Okay.
Mr. Chairman, just a real quick, and first of all, appreciate the fact that you made progress on the property. You've worked with us. It's regrettable that the process was less than pretty to get to there. I understand you're saying you're not involved, but I guess I want you to look at it from this side of the fence for just a minute. I understand all of the issues that people deal with in their lives with work and family responsibilities and paying bills and stuff. We all do that. But interestingly, you look, Mr. Macy's name tag is there tonight. Mr. Macy isn't here. Mr. Macy isn't sick. Mr. Macy isn't on vacation. Mr. Macy isn't here tonight, probably because the town chairman indicated to him that he didn't need to be here. Because when he's here, public record, no surprise, he gets paid $195 an hour for his services. Mm-hmm. For a good attorney, it's not a bad hourly rate to pay for that. So all of the meetings, even when you or any other people come forward, for every part that he sits here, if he were to hear tonight and we spend 20 minutes talking on this issue with you, take a third of 195 and call it $200. And basically it's cost us 60 or 70 bucks just to have that conversation. I don't know the details, but I suspect that there was time and money spent on this previously that he got paid for, that the town has paid for. I full well suspect that's part of it that has not been charged to anybody. So the question I ask for you, is it fair for and the decision we have to make, is it fair for the other people, the town, to pick up the tab for that when we unfortunately have to take some of the actions we need to try to get things accomplished? I mean, that's expensive. It's $320 or what or not. The clock doesn't run very long on his time to get to that. That's a practical reality.
Sure. No, I respect that, Supervisor Fisher, and I get that. I do think it's their responsibility to cover costs in the event that there are, I would say, agreements or conversations that things are being done and things are moving forward. There are times, look, if we never got into the picture and my aunt donated the land, whose responsibility would it be then to remove the house?
Donated to where?
She was talking about giving it back to somebody, giving it back to the town or something.
The town doesn't take donations.
Okay, so whatever the case is, but no, I do. I think it's, yeah, I would think it's the taxpayer's responsibility because, quite frankly, we had conversations. We knew what the expectations were, and we said we were going to do what we did, and we followed through with it. So let me ask you a question then. I guess if I have a noise ordinance, I got a problem with my neighbor having noise, and I come up here and I want to be put on the agenda and talk about it, I'm going to get back charged for coming in here and telling you about my neighbor making noise? No. Okay, so.
Just
so-
like there's no charge for you to be here and talk this issue.
So am I going to get charged here?
No,
The attorney's not here.
that's why,
Okay.
but in all fairness, even if the attorney was here for the town
Right.
board meeting tonight,
Agreed.
a person on the agenda doesn't get charged for the attorney's time while he's here for the town board meeting.
But for me disputing this particular situation, I would still get charged, would I not?
No.
Oh, okay.
And I want to go back and clarify again.
Mhm.
You asked you said the date was the 18th. I'll take your word for that.
Yeah.
And we did stop the lawsuit. That
Mhm.
doesn't mean attorney's fees end.
Okay. Why couldn't you guys make the decision then at that point to stop the review and say, listen, attorney, we're dealing with Nick. He's got a plan in front of us. We approved the plan. He's going to do the right things. Handled. I mean, you have the authority to do that, do you not? I mean, you had the authority, John, last Chairman John, when we talked 2 weeks ago, when I asked you, can you stop billing me after the September 19th? And you said, yeah. Well, why is it okay then for you to stop charging me attorney fees after September 19th? You have the authority to do that. I just, look, we're going round and round. I get it. It's frustrating. It's frustrating when we make a commitment to the town. I capitulate to everything. And I'm even exceeding your expectations as it relates to raising this house. And then to have this slap back on us, and I get it, I get legally, process-wise, I understand all that. And you're right, you're probably right. I'm just asking for leniency.
Let me clarify once more. It's not what we asked for.
Okay?
It's following the ordinances of the town of Waukesha.
Okay.
We were following what we need to do in order to get the house raised. We were preparing to file a lawsuit. We've been preparing for that for quite some time. Didn't take any action on it. When we did take action on it, that's when you bought the house. It's unfortunate. The timing was unfortunate, but that's simply how it worked. Because you bought the house and because we agreed to stop a legal action doesn't mean that the attorney is going to stop reviewing things. It's just not, it just doesn't happen that way.
So
I'm not an attorney and I'm not about to put myself or the town on the hook for things that I may not understand from a legal perspective.
that's fair. So so I can assume then that it was coincidence that the night we missed the meeting, you guys initiate the lawsuit? It was pure coincidence?
No, we were
Oh.
we had on the agenda to go into closed session for a number of different issues. One of them was to talk to the attorney. When we discuss legal issues and strategies, that always happens in closed session with the attorney. We discussed with the attorney what we were going to do, and that was to file a long form summoning the complaint in order to force the house to be raised.
So you're telling me whether I was here or not, I was going to get the lawsuit hit against me
No.
after owning the property? No.
That is not what we said. The first thing I told you was that if you were here
Yeah.
and you gave us some sort of reasoning about what was going to happen,
Right.
perhaps there would have been a different outcome from that during that meeting.
All right. Well, I stated my case. You guys understand my story. I just ask that you guys give us a little bit of leniency, knowing that we did in fact commit and we followed through on every promise. We're not bad people. We're great people. We're great citizens to the town, to the community. And I think we're actually doing a favor. We're helping the community, getting rid of that blight. And that's exactly what we did. And we did it as we promised you guys. I just asked for leniency and for you guys to waive the $320.
Is there a motion?
I'll make a motion that we push this to the next meeting. I'd like to see the actual bills. I haven't seen that and haven't.
Do you want to see them?
I'd like to look at them though, instead of making a decision rashly and see exactly what they were for. and then make a decision at the next meeting.
Largely as a courtesy to Supervisor Radke, I'll second the motion.
Further discussion? Are you asking to table it?
Yes.
To a date certain of the next meeting?
Correct.
Pardon? Okay. All in favor?
Aye.
Opposed? Aye. It is tabled to the next meeting. On to 8, discussion and possible action on Broadway intergovernmental agreement. This is for water main down Broadway within the town of Waukesha's jurisdiction, and council has reviewed the agreement. We really don't have a lot of choice in this. State law does not allow us to prohibit a utility from being installed in our right of way.
I've got a number of comments, if I may, Mr. Chairman.
Yes.
First of all, I fully and completely support the intergovernmental agreement, and I think it's important to highlight that this is an intergovernmental agreement. We haven't had a lot of those in the recent past here in the town of Waukesha. I think, big picture, this is a good thing. I have a personal interest in this, which I'll address in a minute, but I do have a couple of suggestions, I think, to clean up the language on this, and I'll go through them, and I can give this in written form to the clerk later or whatever, but I believe what we're attempting to accomplish here is to allow 3 options to the affected property owners, of which I think there are 8 tax key numbers that are identified in paragraph 2. One of those options, I think, is to construct the lateral to the property lines for each property owner, and individual decisions, but those would be done by the city at the expense of the property owner, as the agreement clearly calls out. And then the property owner could extend the lateral from the property line to the building or structure, also at the property owner's expense. In 2016, which I understand the water main extension or construction is to take place, and service could begin. The second option is, and again, at the choice of the individual property owner, would be to construct a lateral to the property line, again by the city, at the expense of the property owner, and in 2016, when the water main is extended, and do nothing more. And the third option is, I understand that should be available and be spelled out specifically in the agreement, is that the laterals to the individual properties at the choice of the property owner would not be extended to the property line in 2016 by the city, so the property owners would not incur that expense, but they would preserve the option to defer that construction to a later date, the laterals to the property lines. And in all 3 of those scenarios, all the way to the structure, to the property line only, or no lateral extension whatsoever, the property owner would retain the option to obtain municipal water without requiring annexation to the city. That's my understanding of the agreement we're seeking, and I'd like to see language that would spell that out specifically. I can either pause there. I've got a couple of other comments if anyone wants to jump in on that, but the pleasure would be go.
Because that's not how I read it. I didn't understand this to say that there's 3 options. I read this and all the more important that this gets clarified in the agreement, because I read this to say that in item number 2, that between now and at the start of construction, each property owner in these tax keys listed has to decide if they want to pay for a lateral from the connection to the property line. So if a property owner makes that decision and takes that action, during construction, then at a date in the future, they can pay for construction for the lateral from the property line to their structure. I didn't see those as mutually exclusive options.
And basically, I agree with what you're saying, what the document says.
Okay,
So we're on the same page with that.
you're saying what you
But
wanted.
what
to
I'm
say.
saying, what I think we wanted to say, I mean, 6 of the residential properties are on the south side of the road. The water main extension is on the north side of the road. Those lateral extensions under the road to the property lines will be no small amount of change to do that. I don't think we want an agreement that compels that to be done at those property owners' expense. And if you choose not to do that, you're foreclosed from doing that at a later date. So I think the agreement ought to allow for all of those possibilities. I mean, I certainly don't want somebody to construe this that any of those property owners are asking for water service at this point in time, and it would be incumbent upon them to extend the house at this point in time and take the city water. I'm trying to, and I thought what the intention of this was to simply preserve all of those options. So I agree with you what the document says, but I don't think that's what we want.
I would agree.
Okay.
Do you have that written out that you could share with the clerk and get it in the? We can get it to the
A
attorney.
couple of other things quickly, if I might. I am a little bit concerned about the language under paragraph number 4, and maybe one of you can explain that further to me. I'm a little bit concerned and questioning what the language means to be, quote, holding out, unquote. I don't have a real clear understanding of what that is. And I'm just a little bit concerned about the language that says the city does not waive its right to require annexation of any property not described in the agreement. I mean, generally, I agree with that, but particularly what goes on to the top second page that says that this agreement shall not serve as precedent for the provision of water services to the city to other properties within the town. My concern about it, there are now, and this has been discussed many times and well documented, there are over 100 town properties that are either currently, and some of them for decades, served by city water, city sanitary sewer, or both. So, I mean, I would argue that the precedent is already there for providing water services by the city to other properties within the town, because there's well over 100 properties for that. I don't know why that needs to say that in this agreement, and I would guess that I would ask if at least that part of 4 could be stricken or be silent on it. I don't see why that has a purpose here, because the fact of the matter is that precedent has already been set. I don't know if anybody else has a comment on that or not, but I certainly can accept the part where it says that there's no ending area. I mean, I get that part of it, that this is not to be expanded, but the business about precedent setting is contrary to the reality that exists at this point in time. I have 1 or 2 other issues, but does anybody have a comment on that or agree or disagree?
Not on that.
Okay, then the other thing that I would think that I have some personal knowledge of, and that would be simply that one of these properties, in fact, if you look at that map, is a property that I have an ownership in. It is the commercial or business property on the northwest corner of the intersection of St. Paul, West St. Paul Parkway, 59164, and Broadway. If you look at that, it's owned by an entity called the Broad A Corporation, of which I'm the president and the controlling shareholder of. And this agreement, I think, needs to be modified or cleaned up, because that particular property already has, or I'm going to say had for a minute, an existing water service lateral back in 1988. In fact, on November 29th of 1988, the entity that has owned that property for all those years, of which I'm the controlling shareholder, paid nearly $2,000 to extend a 2-inch water service lateral from the water main on the east side of Les Paul Parkway to the west side, 10.5 feet past the curb, for a future connection for municipal water. That was 27 years ago, and that was an option that was offered to the Broad Acre Corporation at that point in time. Has been there for 27 years. Part of the irony to that is when they did the expansive 24-inch water main project there that they began in June of this year and just finished the landscaping where I believe is it Racine or Sunset, but all the way up to Arcadian, and they did the north half of that. They basically abandoned or took out that lateral connection that came across from the other side of the street. I have an agreement, and I have it in letter form with the Waukesha water utility that they will basically restore, replace that water service lateral that was paid for 27 years ago, but take it off of the very 12-inch main extension that we're talking about in this intergovernmental agreement. So I would like to have, and I'll provide the details of that. I'm confident they would do that, but I'd like to have the language cleaned up to reflect the fact that there's already an agreement in effect between the private property owner and the Waukesha water utility to replace that lateral in kind as part of this project. So some of those other things are not applicable to the Broad Acre Corporation. The issues with regard to connecting to that without requirement of annexation to the city and everything stay in place. But I would like to have that clarified. That's my personal interest in it. There's no issue of conflict or whatever with that, but I'd like to have that clarified. That was maybe a bit long-winded. I'd be happy to answer any questions with that, but I have that in written form.
Anything else, or is that it?
Is that enough?
Lenny?
It's not enough if you're not done.
Well, I'm about as close to done as I can. So I guess I would like to ask that we would lay this over and put that in the form of a motion or what or not. I absolutely think we need to get this executed as soon as possible. But having had said those things, so those things can be clarified, I would move to not act on this tonight.
Would you like to not act on it or table it to the next meeting?
Well, I guess appropriately to table it to the next meeting or until such time. And then the next meeting, we can have an update to see whether these things can be incorporated into it. So that's my motion, to table the next meeting.
In a second?
I'll second.
All in favor?
Aye.
Opposed? Motion carries. On to B, ordinance 2015-08, repeal and recreate section 1.40 of the municipal code of the Village of Big Bend relating to establishing a joint municipal court for the Village of Big Bend. Is there a motion?
Is to repeal and recreate chapter 2-7 of the town of Waukesha code.
Mr. Chairman, I will move to enact an ordinance to repeal and recreate Chapter 2-7 of the Town of Waukesha Municipal Code concerning a joint municipal court. And I so move.
Is there a second?
I'll second.
Discussion? All in favor? Aye.
Aye.
Opposed? Motion carries. On to C, the agreement for the operation of the joint municipal court for the town of Waukesha and the Village of Big Bend pursuant to Wisconsin Stats 66.0301 and 755.01 sub 4. Is there a motion?
Mr. Chairman, I will move to approve the agreement for the operation of the joint municipal court for the town of Waukesha and the Village of Big Bend pursuant to Wisconsin stat 66.0301 and 755.01 parens 4 close parens, and I so move.
And a second? Discussion?
On page 2, under item 2, which is essentially starts on page 1, under organization, talks about the committee and the members. When you get to the last paragraph, which is right above item 3, court clerk, says that the committee's chairperson who shall be a representative from Big Bend selected by the village board. Is that the direction that we want to take? I found that interesting. I think that there might be a different way to select a chairman of the committee. Didn't necessarily have the resolution to it, but thought there might be another way to do it other than have the village board of Big Bend do it.
Do we know, Madam Clerk, did the Village of Big Bend meet on this as well this week?
They're meeting tonight.
Thank you.
You raise an interesting, certainly very interesting question. What do we understand, or just fill it out in here as to what the committee chairperson's responsibility, authority, and that type of thing? Do we have a good grasp on that?
When I was at the North Prairie meeting of the municipal court, the chairman just pretty much ran the meeting. So we all had the paperwork in front of us. He just kept the meeting moving forward, and one person took the minutes.
And I would say that the duties are limited. I mean, the only duties that I saw outlined in this document are in that paragraph there, the committee's chairperson, who shall be a representative from Big Bend selected by the village board, shall preside over meetings of the committee. Additionally, the committee's chairperson shall ensure minutes are documented for the meetings and distributed to all governing municipalities. And the committee as a whole has, in my opinion, limited responsibilities also. The budget is set by the judge and submitted directly to the boards, I believe. The Joint Municipal Court Committee shall only act as a research and recommending governing body.
And I understand your point. I mean, it sort of a little bit begs the definition of how is this a joint municipal court? I mean, is that, not trying to put words in your mouth, but does it beg that question a bit? I mean, are you thinking of this should be elected
Well, if I was on a
by the
chair,
group, or it should be a rotating type of thing, or what?
rotating
what is your
or
thought?
elected by the group. Rotating might be good. Wouldn't be opposed to that. Let them have the first shot. It's their court right now. I don't know. It caught my eye, that's all.
Yeah, I don't really have an issue with it. We are joining their court, and as you said, they are somewhat limited on what those responsibilities are. If the roles were reversed and it was based here, I think we would want to insist that a board member from the town of Waukesha was the chairperson, so I really don't have an issue with that.
But in order to change it, we'd have to dissolve the relationship and reestablish it, and I don't know that that's worth going through all that. Go ahead, please.
I don't believe we would have to dissolve it. We can rewrite our agreement at any point. We're not changing the ordinance at all. It's the agreement. And if we remember earlier this year, we went through the North Prairie and we were redoing the agreement. So the way that the funding was distributed would have been different.
Okay. I thought I read it somewhere in here. I didn't highlight it. Expenses for termination, need a member. Withdrawal.
Maybe just while people are looking at it, I mean, I think it's noteworthy even for the small number of people in the audience here, these joint municipal court committee members, of which there are to be 2 from the boards of each community, are uncompensated. So it's not like somebody's going to be richly rewarded for this fine position.
It does also say under court clerk, of course, clerk is an employee of the Village of Big Bend, which would make sense. So again, having a chairperson from Big Bend, again, I don't have an issue with that.
Well, and the court clerk is hired by the judge. The language about being an employee of the Village of Big Bend is just to simplify the tax and FICA
Right.
accounting.
Right.
I think I'm with Supervisor Radke. I don't take issue with it because the committee is simply advisory and has very, very limited abilities. Ultimately, budgets and so forth rest with the boards of each municipality.
I had one other question, if I may. Under item 5, forfeitures, fees, penalties, assessments, and costs. All forfeitures, fees, penalties, assessments, and costs paid to the joint municipal court under the judgment shall be paid to the Village of Big Bend treasurer within 5 business days after the receipt of the money by the municipal court and other court personnel. In the event of the payment, the municipal judge or other court personnel shall report to the Village of Big Bend treasurer the title of the action which the member municipality received judgments, the offense for which the forfeiture was imposed, and costs, if any. The Village of Big Bend treasurer shall disperse the fees and penalty assessments as provided by Wisconsin statute. The remaining 2/3 of the Wisconsin statute 814.651 fees shall be transferred at least monthly to the joint municipal court operational account. All forfeitures shall be dispersed by the Village of Big Bend treasurer at least monthly to the member municipality for which the judgment was entered. Where's the other third going?
It stays in a pot at the court. It's the exact same for North Prairie. And then, if you remember at the beginning of this year, I had stated I pulled out $15,000 in that growing pot at North Prairie because they kept that third there. One, to make sure that if we didn't have another person come in for tickets, that our court costs would be covered. And then anything after that, we can request the check. And that's what we'll be doing in December of every year.
So is that all laid out in the state statutes?
State statutes are talking about how the money is dispersed between the county and what goes to the municipality, depending on the ticket that's written.
I mean, aren't those things that should be laid out in this agreement, or are they laid out in state statute?
I can't answer that. This is the way that it's been run this is the exact same piece that was in our North Prairie document. And we've been running on the same agreement.
Which part were you, what do you want more clarification on?
Where the other third of the 2/3 is? It says the remaining 2/3 of Wisconsin statute 85.65 paren 4 or paren 1 fee shall be transferred at least monthly to the joint municipal operational account. So it talks about 2/3 of the forfeitures, fees, penalties, assessments, and costs. Where's the other third? I want to know where 3/3 are going. If we're going to specify where 2/3 are going, I think we should specify where the other third is going. And I didn't find that anywhere in here. Could be I missed it.
I think the first third, Mike, is in where it states the Village of Big Bend Treasurer shall disperse the fees and penalties assessments as provided in Wisconsin Stats 814, 165, 167, and 346. That's the first third. The remaining 2/3 shall be transferred at least monthly to the joint account.
But then wouldn't it read, the Village of Big Bend Treasurer shall disperse 1/3 of fees, penalties, and assessments as provided in Wisconsin statute 814, 65, 87, 31, 346.65, and the remaining 2/3 of the Wisconsin statute 814, 65.
Perhaps for clarification, it should have said that, yes. My understanding is that the 1/3 is in that. Perhaps you want to wait on this until we get clarification from council on that, that the 1/3 is in the state statutes.
Yeah, I would.
Okay.
Thank you.
So do you want to put that in form of a motion to table this?
Sure. I think that's all the questions that I had. Yeah, because the last one got triggered a little quick onto the table. Does anybody else have anything? That's all that I had on it.
Well, if that's the only issue, couldn't we approve it subject to clarification on that point? Would you be acceptable with that instead of
I'd kind of like to
rehashing?
know what if I'm not happy about where the 1/3's going?
Yeah, I hear you.
Or if it's going in Sir Radke's pocket for coffee shop expenses.
Were we under some obligation to act on this by a certain date? I was under the understanding that we were, and maybe I'm wrong.
We do. We have a limitation to get this done by before November in order to get it to the GAB so they can create the office on the next type A notice for the April election, because nomination papers start on December 1st. That gives the GAB the ability to get everything on the type A notice.
We better hurry up and get it to the GAB before they don't exist.
They're gonna be here a year before anything gets done.
Perhaps Supervisor Radke's thought was pretty good that we approve it subject to clarification of where the first third is and that it is within the state statutes.
No, the motion on the table is to, there was a motion, right?
And a second on the table.
Yeah.
No, I don't think there was a second.
So,
Yeah,
so why don't we just vote on the motion in the second and then move forward?
Well, we don't have a choice once there's a motion to
Well,
table.
no,
I
you
didn't
could
realize
go,
there
you
was a
could go
second.
back and amend it, but let's vote on it, and if somebody wants to do something different, then so be it.
We don't have a choice once there's a motion to table. I didn't realize there was a second, otherwise we shouldn't even have
Otherwise, we
discussion.
wouldn't be talking about
Right.
There wasn't a motion to table.
What was your motion?
it. I don't have one.
There was a motion by Brian Fisher to approve and a second by Supervisor Wolf.
Okay, my mistake. Well,
so you have two options. You can pull back the motion and amend it if you wish, or we vote on it.
Yeah, vote on it.
would you be inclined to accept a friendly amendment of making sure that there's clarification regarding the first third, that it is clarified within the Wisconsin statutes?
Yeah, absolutely.
And Supervisor Wolf?
Yep.
Anything further? All in favor? Opposed?
Aye.
Motion carries. On to payment of the bills. Authorized payment of the bill to Rupert Melking in the amount of $5,817.76. Is there a motion?
I'll make a motion, we approve the Rupert Milky bill in the amount of $5,817.76.
And a second? All in favor?
Aye.
Opposed? And abstain?
Aye.
Motion carries. On to B, authorized payment of the Scott Construction Bill in the amount of $70,457. Is there a motion?
Make a motion that we pay. Make a motion, we pay Scott Construction in that amount.
And a second?
I'll second.
All in favor?
Aye.
Opposed? Motion carries. On to C, authorize the payment of the remaining bills in the amount of $113,087.89. Is there a motion?
I'll make a motion that we approve the remaining bills in the amount of $113,087.89.
I'll second that.
All in favor?
Aye.
Opposed? Motion carries. And a motion for adjournment.
I'll make a motion, we adjourn.
And a second.
Second that.
All in favor?
Aye.
Opposed? We are adjourned. Thank you.